Hello, everyone. We are waiting on a few more people to get access to the webinar. We had a slight delay in getting started here, but we're going to go ahead and get started. And today the subject is dealing with difficult. And my name is Cliff Davis. I'm a shareholder here at Roberts Markel Weinberg Butler Haley, and I'm going to talk with you a little bit about dealing with difficult owners and board members. This one's a little different than a lot of the webinars we present in that there's not really, in most cases, legal answers to this. It's more kind of a subjective way to try to deal with people that are causing you problems. So the things we're going to talk about today are difficult homeowners, board members, try to talk about a few strategies on how to handle them, and then answer questions here at the end, time permitting. So we've all known the different types of owners you have out there that kind of make themselves known, and they make themselves known because they fall typically into a group of people that can cause issues with the board. And one of those is the complainer or the victim who just, they protest everything, big or small. They raise the same issues over and over again. They think that somebody's out to get them, maybe because you have sent them a letter or signaled them out for some issue on their property. They believe it's the board or a specific board member that might be out to get them. And kind of a practice point here that I like to recommend to associations is that when you send a communication to an owner, whether it's a deed restriction violation letter or a collection letter, I generally recommend that every communication be signed by board of directors and the name of the association, and not have a specific board member's name on that letter. A lot of times what I find is that when people get a letter and they see a name on it, it becomes a personal thing between them and that person. They think it's that person that's after them. So I think it's a better practice to sign everything just board of directors. And you've got that watchdog owner who watches everything. They're retired or they don't have to work, and they watch everything that happens. They watch every movement and every moment of the board and complain about things that they see. You've got the disgruntled former director. I'm dealing with several of those right now, where they're upset that maybe they didn't get reelected, and so they just kind of disagree with whatever the current board's doing. And you get a lot of that. When I was on the board, we did it this way. You've got the self-proclaimed lawyer, and that's the internet lawyer who has read the governing documents and probably Googled various association laws and kind of puts their own interpretation to it. And unfortunately, a lot of times their interpretation suits their purposes and not necessarily are the really intent of the law or the purpose of the law. And you have to deal with those people. And sometimes, they might get 90% of it right, but some of it wrong. And they can kind of be a pain in the backside of a lot of boards. And you've got the abuser or the bully. And in the last few years, it seems like we see more of these people who basically just want to bully the board into doing what they want or threatening the board. It's unfortunate. These are the people that think they're right because they talk the loudest or have the strongest personality. And then you can also have a faction, which is a group of owners, and typically they're led by one of the previous types of owners that we've mentioned. A lot of times it results in mob mentality. You get one or two owners that knows a little bit about what they're talking about, or even sometimes a lot about what they're talking about. And they kind of get a following, and typically the following is not as invested as they are, and they don't know as much. They don't know the governing documents or how the association should operate, and they just kind of follow these people, whether or not it's right, wrong, or regardless of rhyme or reason. So the faction typically just opposes everything the board does, and always wants to talk about removing a board member. Maybe they're going to threaten to hire an attorney and file a lawsuit, and in many cases they do that. They get an attorney, and the attorney starts writing letters, and that's just something else that the board has to deal with. And for all of these types, it's verbal abuse toward the board, toward other owners, litigation. We've had some instances where it's risen to the level of threats of violence and actual physical altercations. And obviously, these are things you all want to avoid. We'll talk about how you run your meeting, and a lot of times that can try to head off some of these problems with the way that you run your meeting. A lot of bylaws say that associations operate by Robert's Rules of Order. I typically try to advise boards to not use Robert's Rules of Order, and the reason for that is that most people don't know Robert's Rules of Order. Attorneys don't really use them. We have some associations that use Robert's Rules of Order, and they actually hire a parliamentarian that's very familiar with those rules to come to their meetings to make sure they're going right. Because what we find in Robert's Rules of Order is that people use them incorrectly, and this is kind of an example that we show here, is that there's one thing that, if you know anything about Robert's Rules of Order, you know that you can assert a point of order. And most people use it incorrectly. They use it to request information at a board meeting or ask a question. That's not really the purpose of that. That's another thing to kind of remember, like I said about running your boards, is that it may be a good idea at the beginning of every board member to make an announcement of what the purpose of the board meeting is. And owners are typically not participants in the board meeting. Owners have the right to attend the board meeting and watch the board conduct association business. It shouldn't be a back and forth. We find a lot of times that a back and forth can kind of really ruin a meeting or lead to an argument in a meeting where the board allows owners to question them and question what they're doing while they're doing it. So kind of asserting something at the beginning of, this is what you're at. It's a board meeting. You're here to watch the board conduct business. We do recommend that at some point in the board meeting that the board give owners the opportunity to speak if they've come to a board meeting and say what's on their mind, and you can limit that to a time or a number of questions that an owner can ask. And if you have an answer to the owners, answer their question there. There's nothing that frustrates an owner more than to ask a question and not get an answer. So try to answer questions if you can, and give everybody, if they've made the effort to show up at the board meeting, give them a chance to talk, but try to control how they do that. And it may be, you may have to at some point remove an owner or threaten to remove an owner if they cannot act like an adult and have a discussion like an adult. Not only are owners difficult, but board members can be difficult too. You've got the dictator, and they rule with an unreasonable and inequitable iron fist. And a lot of times this is the board member that's been on the board forever, and they've kind of believe that the association is kind of their little fiefdom, and they want to run it and no one question their rules. And unfortunately, in a lot of cases, a lot of associations, we see that the other board members allow this to happen because they're not as invested as this board member. They may just be serving 1 or 2 terms, and this person's been around forever, so they just kind of follow their lead. And rarely does this turn out well when you have this type of dictator, because inevitably there's a board member that believes that something's wrong and that questions this person, and that can lead to discord on the board. And then you've got the double agent board member, and this is a lot of times, to me, this is the board member that he's there for the owners. He makes that claim a lot. I'm here for the owners. And really, what a lot of board members don't understand is their duty is really to the corporation and not necessarily to the owners. What's good for the owners is not always good for the corporation or good for all of the owners. And you get these board members who try to play both sides, and that can be problematic too. And again, you've got the same type of board member that may be like an owner that just complains about everything. And especially if they're in the minority and no one ever agrees with their decisions, that makes them very upset, and they believe the rest of the board is against them. And then you've got the sloth, which is what a lot of boards experience, is the type of board member that just doesn't do their job. They don't show up. They don't participate in votes, in votes between meetings. You can't get a response out of them. And you've got to try to figure out ways to deal with all of these kind of people. And one thing that every board member should be aware of, and every manager should make their board member aware of, is the standard of conduct for a director. And a lot of times we hear in meetings and just out of meetings, the term fiduciary duty is thrown around a lot. And unless the association's governing documents impose a fiduciary duty, board members do not have a fiduciary duty. They have a lesser duty. It's generally called a duty of good faith and ordinary care. And this slide here shows the Texas Business Organizations Code statute, which is applicable to nonprofit corporations and to homeowners associations, that states what a director duty is, and that is to act in good faith with ordinary care and in a manner the director reasonably believes to be in the best interest of the corporation. Again, this is a lesser duty than a fiduciary duty, which is the highest type of duty that someone can have to an entity or to an organization. So the similar duty applies to the officers of a homeowners association, and that's also this statute that's from the Texas Business Organizations Code, and you can see that it's really the same duty that a board member has. So it's simple. Some of the simple things that we forget sometimes is how directors should act, and you really want to be, when you're handling association business, a little bit distant and professional, to try to show owners that you are trying to act in the best interest of the association. And the way you can do that is treat people with respect, remain objective, prepare for and attend meetings. And prepare for meetings is a big one. All board members should be encouraged to know what the issues are before the association, to research those issues if they need to read what the management company is providing them. And the board obviously should try to speak with one voice. And that doesn't mean that a board's going to get along. And that doesn't necessarily mean that the owners should never see the board members disagree with one another. It's how they disagree and how they resolve that disagreement that really can give owners some confidence in what the board's doing. A lot of times a board member may get outvoted, but they need to be encouraged that when that happens, to support the decision of a majority of the board. And what I try to tell board members who are getting outvoted and they're complaining about it is that they need to find like-minded individuals and have them run for the board if they think that things are not being done correctly, or that things would be run in a different way would be better for them. Typically directors should not ever accept gifts, gratuity, favors, or for financial, contractual, or personal benefit. Definitely something you want to avoid is the appearance of impropriety, but even the appearance of it can be bad for the board. We typically don't have any boards that receive compensation for serving for the board. That's not unheard of. There are some boards that might receive compensation if their governing documents authorize it, but reimbursement is not compensation. So if the board member spends money on buying supplies for an association event, obviously being reimbursed for those supplies is not compensation and is something that's acceptable. Board members are exposed to a lot of confidential information regarding delinquent owners or deed restriction violations of owners. Obviously, that should never be shared with anyone outside the board. And then another issue we see a lot is board members stating their personal opinion on something, which the fact of the matter is that if you serve on a board, when you say something, people are going to take that as the position of the association. And so you have to be very careful about representing your personal opinions. And this is one of the reasons why we generally recommend that board members stay off of social media that's not sanctioned by the association. For example, the Nextdoor app that a lot of people use, and there can be a lot of craziness out there on that app. And a lot of times a board member might weigh in on Nextdoor, and sometimes they may, phrase it that, well, I'm on the board, but this is not the association's opinion, this is my opinion, and they state something, and people don't really hear that first part. They hear a board member speaking and believe that it's an association position. And, for one thing, no one's ever won an argument on social media. And we know that out there on the Nextdoor type apps, there are people saying bad things about board members. There are people that are presenting misinformation. And it's just generally not a good idea for the board to try to address that out there on Nextdoor. We believe a better way to address those types of things is, if you know that there's misinformation out there, is then to send a directed communication either by mail or through your management company, through your email contact list, that starts off with something like, we understand there is a rumor in the community that blank. These are the facts. And try to get your word out there in that manner and not trying to argue with someone on social media. I'm sure if you've ever looked at Nextdoor or just any type of social media where there's a back and forth, what happens is when someone is shown that they're wrong in what they're saying, they just kind of move the goalpost a little bit or change the argument. And that's why I say that you're never going to win an argument on social media. You should try to respond if the board believes it's necessary to respond to something going on out there. It's better to respond in a kind of a dry, factual manner and try to get that information out to your owners, what the facts are, and not what somebody's opinion on social media are. And the other thing that I try to tell board members is, look, you're going to have a thick skin. If you look out there on social media, people are going to say things personally about you. And a lot of times you've just got to kind of get over that. My experience is that the people that are looking at Nextdoor on a neighborhood association type website, it's the same small group of people, and it's just kind of an amen choir where they all bless what everyone else is saying. And most of the association is not reading that. Most of the association is going on about their business. They're paying their assessments on time. They're fixing issues when they get sent a letter, and they have no idea that that's going on. And I try to tell board members that, look, you can't get too upset about that stuff out there. That's kind of the benefit of being on the board, is you get to hear people say bad things about you on social media. Another thing to think about when you're on the board is obviously liability for the association and liability for yourself. So again, you fall back on that business judgment rule, that those two statutes that we showed previously that show what the board members, the standard of care is, and it's in good faith in a reasonable manner. And as long as you act that way as a board member, it's be very difficult to get to personal liability to you. Board members can expose themselves to personal liability if they do something criminal as part of being on the board. If they, sexual assault or sexual harassment on the board is something that can lead to personal liability. Those things aren't covered. It's really just a common sense. If you want to avoid personal liability, you act with care. And one of the ways that you can act with care is to follow the instructions of a professional or follow the advice of a professional if there's an issue in front of the board and the board's not sure how to act or what to do. And that's when the board should consult with this professional and listen to that advice and take it. Insurance coverage. I tell every board member, when you're shopping for insurance coverage for the association, that you're not shopping for the cheapest price, you're shopping for the best coverage. And this is one instance where you want to have the Cadillac and not the Yugo, is to buy insurance, because that insurance will be the thing that if the association sued, and in a lot of lawsuits these days, they name board members. If they name you as a defendant, you as a board member, that's the insurance that's going to cover your defense. So you want to make sure that you consult with an insurance professional, and that it's going to provide a good defense. And again, this is not shopping for price on insurance. It's shopping for coverage. If you have a board member that is doing things that they shouldn't do, you've got to defend on how to handle them. And one of those ways is to think about a vote to remove the board member. Typically in an association, if you want to remove someone from the board, it's going to take a vote of the owners, and that procedure should be in your governing documents. Again, with the insurance, it's not guaranteed. If you do one of those things, if you're a board member and you engage in that behavior that I talked about, criminal behavior, sexual harassment, civil rights violations, those kind of behaviors are typically not going to be covered by insurance if you get sued. And there is typically indemnification language in the declaration about board members and also in state law. And if you engage in one of those behaviors, that indemnification language may not apply to you. So really, it's a common sense thing. Act in good faith with ordinary care and make reasonable decisions, and you shouldn't have any issues with personal liability on the board. General strategies, again, tackle the issue directly. And this goes back to things like, if there's a problem, address it. And if you're a board and you need help, then that's when you consult with your professional. If you're a plumber, if you've got a plumbing problem you talk to a plumber. If you got a legal problem, you talk to your attorney. And this is where the management company, should advise the board and direct them to the correct professional to help them with whatever issue they're having. I kind of mentioned this before, is the board should try to be professional and respectful, even in the face of someone who's being rude, who's engaging in inflammatory behavior. And that's the hardest thing for board members to do, I think, is when they have somebody who's disrespectful, who's screaming, who's yelling, who's spreading false information, is to coldly respond to them with facts and handle them in a professional manner. Obviously, leave personal issues behind, do what's best for the community. And again, this is all kind of goes back to the statute of the standard of care. The duty for a board member is be reasonable, act in good faith with ordinary care. These are all just kind of two sides of the same coin for those types of issues. When you've got that owner that you just cannot appease with anything, there comes a time when you may have to decide that you're going to cease communication with that owner. And I think every HOA attorney gets that complaint where there's an owner who just bombards the association with questions. And when you answer those questions, it's either not the right answer, or they, again, move the goalposts a little bit, or it just leads to more questions. And there comes a point where you have really explained the answer to that person and explained whatever the reason is why the board's doing what it does, but it's not going to satisfy that owner. And you've got to make a decision. And I've, in many times, either advised the manager how to do it, or sometimes done it myself, where I contact the owner directly and say, you have asked about these issues. They have been explained to you. There is no other information the board can give you. The board's not going to respond, or the manager is not going to respond to any more questions on this issue. And if you have a question, you can submit it. The board will review it to determine if a response is necessary, but you're not going to get a response to every question you ask. We have some boards that have asked us to inform the owner that they're not going to answer anything from them, and they're not going to, if that owner wants to contact the board, they have to send it to our office in writing, in an email or in a letter, and we will handle it from there. And it's risen to that level on a number of occasions. I'm sure you've all seen that type of owner. If you're at a meeting and you have an owner that is disrupting the meeting to the point to where the meeting can't go on, you've got to be able to stand up to that owner and tell them that they need to stop what they're doing. And if they don't, they're going to be asked to leave. And if they're not asked to leave, then the board's going to call law enforcement and ask law enforcement to remove them. Hopefully it doesn't get that far, but I have seen it get that far. And typically it's embarrassing for everybody involved, but it's necessary in some cases. And then obviously, like I said, talk to the association's attorney on how to handle them. Like I said, sometimes we tell the owner they have to direct all communication to us, or we inform them that the board is not going to communicate with them any further. And a lot of times, for whatever reason, the owners take it more seriously if it's something coming from the association's attorney. For board members that will not act right or are causing disruptions, if they are an officer, unless the association's governing documents say otherwise, the board can remove someone from office. And I think in most associations this is the case. And that doesn't mean they're removed from the board. It just means they're removed from their officer position. So that's a board vote. If you need to remove the secretary, that's just something that you should put on your agenda for your next board meeting, remove them. And if you want to fill that position again, that has to also happen in the open session of a properly noticed meeting. So you can remove them from office, but not remove them from the board. If it's too bad, then you've got to think about removing them from the board altogether, which I said is typically going to take an owner vote, meaning you will have to get quorum, whatever your quorum requirement is. You will take a vote, and the quorum requirement may be the 25% of the total votes of the association at the meeting. It may be a vote of the entire association. We generally believe in removal that it should be difficult but not impossible to remove a board member from the board. Some documents are written to make it more difficult than others. So that's something you need to first look at if you get to that stage of what does it take to remove that director. And if it's an impossible standard, you'd have to consult with your attorney to see about maybe amending the bylaws to make it a little bit easier to remove the director. But like I said, we generally believe you don't want to make it too easy, because then you may have this constant votes on removing board members over and over again. So it needs to be difficult but not impossible. We've kind of talked about all these things of how to handle some of these type people. You know, the watchdog, the one that's pointing out what you're doing wrong. You know, listen to them. They may be right, and if you're doing something wrong, then fix it and let them know that you fix it. The disgruntled former director, the complainer, and the victim, you know, these are the people that at some point you may have to cut off communication with them, because it's no longer them asking questions for a constructive purpose. It's asking questions for harassment, and it's asking questions with no matter what answer you give them, you're never going to satisfy them. So, you know, we've talked a little bit with how to deal with some of these people, and it's again, a lot of times there's not a legal answer on how to do this. It's trying to handle it in the best way to try to get that behavior to stop, which sometimes may involve having to get your attorney involved. And in some cases, rare cases, it may involve filing a lawsuit against that person. Board members, again, if you've got a problem board member, the first thing you should think about is removing them from office if they're an officer. The next thing is having a vote to remove them from the board if it rises to that level. And that is going to take a vote of the owners unless your documents give you some other out. There are some documents, and we write our bylaws to such that if a board member misses 3 consecutive board meetings without cause, you know, which might be they have a legitimate work-related issue, a family issue, an illness issue, that the board can remove that person from the board. And the argument is that they are clearly not participating, and that you want a board member on the board that will participate. So a lot of this goes, you know, to knowing what your governing documents say about how to handle board members, how to remove board members. On the owner side, it's just kind of a common sense, reasonable approach to how to handle problem owners. You know, for the management company, the management companies may have issues with the board too. A board that has unrealistic expectations, a board that, in some cases, the level of issues they have with the manager may lead to where that relationship might not be able to go on. It may rise to the point where the board is simply harassing the manager. So the management company has to come up with a strategy. And a lot of times that might be changing managers, or looking at your contract and making sure that your contract has a termination provision if to let either party get out if there's a relationship that's gone bad. You know, what our experience is that when a relationship with a management company goes bad, sometimes it can't be fixed. And so you want to be able to make sure that there's a way for both parties to get out of a contract that's just simply not working. So that's kind of it for today. This was a short one. I will be happy to try to answer some questions. If you want to type a question into the chat room, into the chat box that you can see, and I'll try to answer any questions. And it looks like I have some. Will we get a copy of this presentation? I believe that every participant will get a copy of this presentation emailed to them. The presentation is also available on our website, which is rmwbh.com, along with most of the other webinars we've done and other educational materials on a variety of subjects. So you can see that on our website at rmwbh.com. Do associations need to adopt and record a code of conduct if one is not already contained in the governing documents? You know, I go back and forth on this one. We have a lot of associations that have a code of conduct, and it works in some associations. You know, if a board member violates a code of conduct, a lot of times your remedy is still the same. Because they violated the code of conduct, you typically can't remove them from the board from that unless your governing documents, and in this case, I would mean your declaration, gives you that authority. You can censure them in a public meeting if they're acting inappropriately, and that might be something that prompts a board member to change their behavior. Sometimes not, depending on the type of person they are. But if the code of conduct is something I would definitely discuss with your attorney to discuss your specific situation to see if you think that's something that's going to help in your case. Should a manager's name be included on violation letters or management company? I definitely think there should be the contact information for a manager in a violation or a collection letter of who to contact about this. And there should be the name of the management company and the management company's address. But I generally recommend that the signature be the board of directors. The manager or the management company is not trying to collect that money. The association's trying to collect that money. I mean, they're your agent and they're kind of the vehicle through which you do that. But their contact information should be in there is what I advise, but I still recommend that the signature be board of directors. And we show the PowerPoint. Yes, I think we've already reached that. The no further response is effective, but infuriates the difficult personality. It does, and I've experienced that many times where it really enrages that person and they double their efforts on sending emails. And, a lot of times, I think the thing that makes them the maddest is that they're not getting any response. And hopefully they wear themselves out. But again, if you engage with those people, it comes to a certain point where it just doesn't matter what you say to them. They're not going to like it. They're going to change what their question is. And it's just going to be an ongoing, continuing thing that will go on forever unless you cut it off. Can a director quiet the homeowner at a meeting by stating point of order? I think that the way to handle that more is that statement that I discussed about at the beginning of the meeting, maybe, where you tell the owners that are there at the meeting that this is a meeting of the board of directors of the association, that the purpose of this meeting is for the board to conduct business. The owners are entitled to attend the meeting and watch the board conduct the business, but they are not participants in the meeting, and that everyone will have a chance to ask a question. And that's not to say that at some point the board may stop what they're doing and address the owners, but you don't want to give the owners the feeling that they are there to be a back and forth participant. So I don't know if I would say a point of order. I would just remind an owner that, look, this is for us to conduct business. We'll hear your question or comment at the end. So we're going to ask you to be quiet. And if they refuse to do so, that's when you have to kind of raise it to the next level, which would be, we're going to ask you to leave the meeting. And if they won't leave and they continue to disrupt the meeting, is that if you don't stop, we're going to call law enforcement, and then call law enforcement if that's what's necessary. If a board member is distributing complete sets of financials to owners, are there immediate repercussions? So if a board member, generally the financials are available to the owners, but not anything specific about an owner. So you can't say a board member should not be telling anybody that John Doe owes the association X amount of money. They should not be disclosing the debt of a third party, an owner, to anyone else. If they are doing that, I don't know that there are immediate repercussions, but there can be repercussions in that owner could sue the association and sue that board member. So, that's the type of thing where you have to tell the board member that it has to stop, and perhaps censor them in an open session of a board meeting, and consider a vote to remove them if they just won't stop it. And you tell the owners they are disclosing, we're having this vote because this board member is disclosing private financial information to third parties, and we believe it exposes the association to liability. So you've got to address that kind of behavior, I think, head on. If a board consistently violates Chapter 209, what remedies are available through JP Court? I think that's question would have to be to talk with your attorney about specifically what the board's doing and what the proper remedy would be. Typically a JP court or a justice court doesn't have injunctive authority, meaning they can't order something to happen. Typically, a JP court case is about money. Now, there's a few exceptions to that, but that's something where you really need to discuss that specifically with your attorney and talk to them about what remedies you may have to stop that behavior. Not a lot of questions today. I don't see any more. So if anybody wants to type one in, we've got a little bit more time. Can open up to any kind of question. For those who choose to post on Nextdoor, we're finding that the posts are defamatory and slanderous. How do we stop it? So this is a tricky issue for associations because a slander cause of action or a libel cause of action is really not an association's cause of action. It is the person who is being slandered. It's their cause of action. So a lot of times what we do is we will write a letter to that owner and warn them that what they're saying, is slanderous or libelous. But if they continue to do so, there's not a lot the association can do. That's where some board members may have to get their personal attorney involved in that. The other thing we find is that a lot of times what board members think is slanderous or libelous is not really. It's just an owner stating an opinion that might negatively reflect on a board member's opinion. So again, that's one thing when that's happening is to consult with your attorney and talk about what those remedies are. Again, the association may write a letter or two, but if it's truly slanderous or it's defamation, that's typically going to be something that the individual board member may have to deal with on their own with their personal attorney. Can we require a Facebook group within the community be taken down or renamed? Possibly with the name issue, if they're using the legal name of the association, you might be able to get that taken down or renamed. But just because there's a group out there that are saying bad things, you're not going to be able to get that removed. And really you shouldn't. A lot of times when we write these letters to owners who are causing problems and tell them, that this behavior is harassing, you need to stop, what you're saying is defamation, you may have some liability, is they'll take that letter and post it to social media and say, look, they're trying to shut me up. They're threatening me with their attorney. And that's something you have to weigh is do you want to send that letter? Is that the type of person that's going to do that? And, again, if they're the leader and they've got these followers who aren't really paying too much attention, it's the followers are just say, they're right. They're trying to, shut people up, free speech. So a lot of times that can backfire when you send those letters. And again, it's just something that for that specific situation, you need to discuss with your attorney. Any suggestion in dealing with a renter that continues to have police visits due to domestic violence and the owner is aware but not taking action? So something that you have to remember is that the association can enforce its governing documents. It's the extent of its authority. What that's describing is really a criminal situation. I don't know that the association can play a role in that other than if it's aware of criminal behavior to report that to law enforcement. I would probably be really careful about talking to an owner about that type of thing. It's again, that's something depending on what it is, you might want to talk to your attorney about how you would approach an owner if there's illegal activity going on at a property. But I definitely would encourage boards and complaining neighbors that if they see something they think is criminal activity, to make a call to the police and try to establish a record of those calls of the police visits to that property. Can one board member make a decision singularly if the other members recuse themselves? I believe they can. I mean, let me think about that for a minute. So if it's a vote, I'm gonna retract that. If there's a vote that has to be made and there's a 3-member board, at least 2 of the board members have to agree. So a majority of the board for that to be a decision of the association. So the answer is no. A recusal or abstaining from a vote is as good as a no vote. Can you remove a board member that was only kept on board by request but has taken back control? Treasurer acting like president and bypassing manager. I think I probably need some more information on exactly what's happening there, but the general answer is the board, unless your documents say otherwise, can remove somebody from an office, but it's going to take a vote of the owners to remove the person from the board. Often we hear from owners that receiving violation notices from the board is harassment. What constitutes harassment and is something the board needs to be concerned about? Under what circumstances could an owner win a harassment suit? So sending violation letters is not harassment. Now, there may be a difference of opinion on if there's a violation or not, but I think I'm going to stick to that statement that sending a violation letter, unless it's clearly not a violation and the association is sending letter after letter over something that's been resolved or is clearly not a violation, but the association is claiming it's a violation, that might be an issue. And again, keep in mind what I said, that you can only enforce your governing documents. When you send a violation letter, you need to be able to point to somewhere in the governing documents to base that letter on. And, again, in those violation letters, a lot of the times we see what the issue is that they don't accurately describe the violation, or they don't describe the violation clear enough. So, when you send a violation letter, the owner should be able to look at the letter, read the description of the violation, and know exactly what you're talking about. So a lot of ways to avoid some of that is to have accurate descriptions, but I don't think that it's definitely not sending a violation letter or a collection letter is not harassment. Under what circumstances could an owner win a harassment suit? I don't know that that's something that's really quantifiable, and I'm not even really sure that harassment is a cause of action. The allegation in the lawsuit would probably come under something different, be a different cause of action that's described. If you hold a meeting in a public library, how do you prevent non-owners from attending the meeting when the meeting should be open? I think it's the same. If somebody's in a meeting that shouldn't be there, you need to ask them to leave. And if they refuse to leave in the library, you would have to talk with whoever's the manager of that facility and tell them that you've got somebody here that's not supposed to be here. And, ultimately that's another situation where law enforcement may need to be called to have somebody removed from a meeting. They should not be there. Do you have an example of a one-page code of conduct? Not really. Again, if you need a code of conduct, contact your attorney and see what their advice is and what needs to be included in that code of conduct. Can a total collections amount due from an owner or owners to the HOA be discussed to the owners other than at the annual meeting? The answer is the information you can give about accounts receivable is a summary. So you can say that the association's accounts receivable for unpaid assessments and other charges is $50,000. And you can do that, in your newsletter. You can do it at a board meeting. You can do it at the annual meeting. What you can't do is say it's $50,000 and here's a list of each owner and how much they owe. That's what you should not do. But you can present that information in summary form. No more questions for now, and I think we're about out of time. I'll give anybody a couple more seconds to type something in if you want. If not, thank y'all for coming. Keep your eye out for our next webinar, which I'm sure if you're on our email list that you'll get an invitation to. And if you're not on the email list, but somehow you've made your way here to this, you can contact the firm, go on our website and contact the firm and ask to be added. Okay, thanks everybody for coming.